You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. And our guest today is truck lawyer, specialist, all-around great person, and just someone I've known by reputation and looked up to for a long time, and now the pleasure and privilege of having on the podcast, Tim Whiting. Tim, welcome to Best Practices.
No, thanks for having me, Kenny. I really appreciate it when you pulled me aside at the TLU conference and said, "Hey, I heard a lot about you. I followed you. I know I met you a few times, but really want to get you on here." Man, I've been so excited since you asked me. So thanks for having me. And this is just a real honor, part of my career. So thank you.
Yeah, and same for me. Tim, for folks who don't know you, share a little bit about who you are and your practice.
Sure. I'm out of Chicago, Illinois. I'm also licensed in Wisconsin, where I grew up. And it's just a small town country kid, and wanted to make it big in the big city. So after I graduated from law school, I decided to start my career in Chicago. And funny was that I was really planning to just stay for a couple of years, get the experience, and go back and practice in my little town of 3,000 people. And 20 some years later, here I am. And it's been quite a journey, Kenny, as a trial lawyer. But I know we're going to talk about that, but my practice is focused solely on people that are hurt or killed in truck wrecks. And we can talk about that journey as well. But that is what my practice is. I get brought into cases around the country, and I love what I do, and I just stay curious about getting better at what I do. And it's just been a really beautiful journey.
Fantastic. When you first started practicing in Chicago, were you doing plaintiff's work? Did you get sucked into big law in the big city?
Yeah, great. Good question. I was a wrestler growing up, and when I moved to Chicago, I didn't have any friends. I didn't know anyone, didn't even have a job. And my wrestling coach said, "Hey, look up this guy, Louis Goldstein. He was a med mal lawyer here in Chicago." And Louis's kid was a state champion wrestler, scholarship at Madison, where I went to law school. And so I called up Louis and I said, "Hey, Louis, I'm a former wrestler. Now I'm a lawyer. I'm here in Chicago. I don't know anyone." He says, "Come on down to my office." I come down to his office, and he's, by the way, at the time in his 60s. And I walked through his door, and he charges me and puts me in like a headlock. I tell that story because Louis became a mentor, and Louis helped me get my first job. And his advice to me was that if you want to be a really good plaintiff's lawyer, go to work first as a defense lawyer. They'll let you try cases. They'll let you work on expert depositions. They'll let you do a lot of the hard work on a file. And so he introduced me to a large insurance defense firm here in Chicago. And that's really what started my career to becoming a trial lawyer. And he wasn't wrong. I tried about 3 or 4 cases a year as a defense lawyer for about 4 years, and always had an eye, though, on representing people that are hurt or killed in by the negligence of others. And so that I knew was my path, but that really laid the foundation to become the trial lawyer I feel like I am today.
And Tim, going back even to before when you began practicing law, what was the motivation, or was there a seminal moment that made you say you not only wanted to be a lawyer, but perhaps be a trial lawyer, and even more so a trial lawyer who represents people's interest after someone's been negligently hurt or killed?
Yeah, I'd love to tell you there's some deep meaning that got me into being a lawyer, but the truth is uh, that we had a large family and not a lot of money. And so in fourth grade, our teacher had asked us to write a book report about what we wanted to be when we wanted to grow up. And of course, most of the guys talked about being a professional athlete, baseball, football, and I pretty much knew that wasn't going to be me. And so I started searching through the library and for things that might inspire me for this book report. And I saw Belli's book on the King of Torts. And I pull it off the shelf, and this looked really interesting. And I started reading that thing, and you remember how just ostentatious he was. He was just such a big personality. He was winning verdicts all over the world, and I'm like, that's who I want to be. And so that partly was because of his financial success in winning verdicts and being very successful financially because of his trial verdicts and wins. And so that really started me off on the road of being a lawyer, because I thought to myself, there's one way for me to kind of get out of the place I was to becoming financially successful, was to be a lawyer. And and then once I got into being a lawyer, that all changed. And then the deeper purpose did come finally, after I started representing people and really sitting in their kitchens and hearing how a crash or a fall or whatever medical malpractice case just changed them and changed their family and caused things that just were taken for granted, like putting food on the table, were taken away from them. And then that's when I knew that this was important for me to be really good at what I do, so that when they come to me, they're putting their trust in me, and they're putting their trust in us as trial lawyers. And we can't be frauds. We have to know what we're doing to be able to handle their case, or we shouldn't do it. And so once that happened, once that click took place, by sitting in people's living rooms and hearing all of the tragedy that they were going through, that's when I realized, like, I really needed to commit myself to this deeper purpose of being really good at what I do to help them.
Yeah, and Tim, you're such a thoughtful person. I mean, that was one of the first things I noticed about you when I'd read listserv posts or when we'd meet incidentally. And then you were in Columbia one night having dinner before an event. We were actually supposed to be trying a one-day case the next day that got continued and later tried it a couple times, different stories for different days. But you talk about your journey to become a trial lawyer, and I think what you're describing is the difference between a journey to become a trial lawyer and a journey to become a lawyer who tries cases from time to time.
Mhm.
Not that necessarily the trial lawyer is constantly in trial, but let's talk about your journey, not to be a lawyer who may come up for trial and may or may not try a case, but your journey to become a trial lawyer with the skills, with the preparation, with the commitment, devotion, focus toward trying cases.
Yeah. So, and you're absolutely right. Really, when we
Let me
talk,
and Tim, let me mention this for anyone who's listening, you know, for God's sakes, I mean, if being a trial lawyer isn't what gives you the most satisfaction professionally and in your personal life, and you don't want to do litigation, or you don't want to try cases, or you want to try the occasional case, but you really do enjoy the other aspects of representing human beings more, then please. This isn't a contest. It's not a judgment call. It's about deciding what your passion, what your calling may be. And again, for Tim, it's that journey to becoming a trial lawyer. But I thought that was important to say because I never want people chasing someone else's dreams.
absolutely, Kenny. And we talked before that we're going to talk a little bit in this journey about comparison, because you shouldn't compare unless it's going to channel something inside of you to be better. Um, but back to your question about my journey to being a trial lawyer, really started from my worst loss as a lawyer. And it was back in like 2007 or 2008. It was at the time, I was doing some medical malpractice work, and it was a psychiatric case. It was really sad. Big life care plan. Kid was pretty much, brain dead, and his mom was caring for him in her home. And they really needed a good trial lawyer. And the state, it was against the state, and so the state really didn't settle any cases, and so this case was going to trial from the start. And that was my first time that I realized that I need to get my skills together as a trial lawyer, because up until that point, I was handling trials that were auto crash cases, or nothing really too difficult, but also didn't require a lot of skills. And so, I won most of those. There was a few hits here and there, but losing one of those or getting a lower damage figure wasn't that big of a deal. This was very different. And I did do the work, but the thing that came from that loss and watching the disappointment, I remember the client's mom, when the jury read not guilty, the mom looked at me and she goes, "Does that mean we don't get any money to help my son?" And Kenny, right now I'm emotional about it. My heart is beating and fell to my stomach, because I felt like I let them down because I hadn't developed my skills as a trial lawyer to try that case. And looking back, maybe I should have stepped out, or I should have brought someone in, but there was a lot of ego things going on, and getting the big verdict was one of those ego things. And so it was a really humbling experience. And it took me a good week to really reflect on this and really let it eat me up, because I think when you let the feeling in of a loss is where you get your biggest inspiration and motivation to learn and get better and be better. And so I remember looking myself in the mirror after a couple of days of not going to the office, feeling sorry for myself, of course, feeling horrible about this family. I remember looking myself right in the mirror and saying to Tim, are you going to be somebody, and it's okay if you are, you're going to be somebody that's just going to go out and hustle cases and, make some good money and get some good results by settlements with clients with their, again, like you said, Kenny, there's nothing wrong with that, because, sometimes that's the best thing for clients. Or and I looked myself in the mirror again about, or are you going to become a great trial lawyer? And I personally made the decision that I wanted to be a great trial lawyer. And the only way I was going to be able to do that was to start honing my skills. And it was going to require a commitment, and it was going to require practice. And one of the beautiful things about being a trial lawyer right now in this time is that we're in a golden era of trying cases. I mean, there are more books, there are more seminars, there are more people willing to share their skills. Like we talked, I'm right now doing the Trial by Human mentoring program that Nick Rowley and Joseph Wilson and Henry Paycor are putting on. And I mean, I'm getting my ass kicked. And I think I'm a pretty darn good trial lawyer at this point, but man, it's pushing me, it's making me feel uncomfortable. And there are so many opportunities like that to practice our skills. Because I think to be a trial lawyer, you really, you have to practice your skills. We commit here at our firm that twice a month we do focus groups more than twice a month, but twice a month, two of those focus groups at minimum are on jury selection or opening statement or closing statement. And so we bring in live jurors, and I practice. And I started that right around COVID. And I think that after all that practice, now I feel like I can replicate that almost without looking at a note when I go into trial. And that's what I think that trial lawyers need, is more practice. I think there's this notion that we can prepare the case through depositions, we can go to pretrial and win some motions in limine or lose some, and then we go back and we write out our jury questions, we write out our opening, and then we just get up on our feet. But that's performing. But to be able to perform at a high skill, a persuasive high trial lawyer skill level is really where I think it is most important, is practice.
Yeah, and one of the first people I heard who shared it in a way that really resonated with me was Rex Paris. And the point he was making was, look, these are skills. And like many other skills, they're skills that anyone, or at least most people who take the time to develop them, can demonstrate. But the amount of time, commitment, effort, and focus that's needed to develop those skills, that's the extraordinary part. That's the part that you just have to make a decision on twice a month or 3 or 4 times a month. Are you going to make the preparation for the focus group, the participation and performance of the focus group, the uh, playback of the focus group where you're analyzing what you did well, what you didn't do well, what you could do better, how you do it differently. I mean, if you're making those things a priority, you're probably going to do well when the lights come on. You know, if you can make, coaches always talked about, if you can make practice harder than the game or replicate the game conditions, um, typically people do better. I mean, I saw that it's one of the best workshops I've ever been in. It was out at TOU with Dan Ambrose in Huntington when you and I were talking. But the first day, I think I got there a day early and went to Ben Rubinowitz's workshop on cross examination. And the word that Ben used was reflexive. So that cross examination, the questions you have, the way that you're asking them, when you're asking them, the sequencing, it's reflexive. But that reflexive um, ability only goes back to, like Rex talked about, taking time to hone the skills and then practicing them over and over and over. Because if you're like me, man, I might be really good at something in October, but if I don't do it again until December, I mean, hell, if I don't drive for a week on vacation, when I first get back in the car, it feels kind of funny. And if you're only in a courtroom, once a year, uh, and it feels real funny.
Yeah, it does. Kenny, especially if you're not practicing, if you're getting in trial, and it's sometimes it does happen. You're only getting in trial once or twice a year, especially on a bigger, if you're handling bigger cases. It's really, as Joe Fried always says, you're a deposition lawyer at that point. And but but the practice is what keeps you honed in. But I want to talk a little deeper too about, being a good trial lawyer and practicing, which is a commitment, and, participating in all these trial lawyer conferences where you actually got to get on your feet in front of the lawyers. Because, one thing I've learned about this trial by human mentoring program is, I am so if I get in front of a live jury, I mean, my breath work is fast, my heart's racing and everything, but within about maybe 2 or 3 minutes, I've calmed down and I'm in the groove and I'm just talking to them, and I have my, because I've practiced so much, I can put on a quick jury selection on asking for money, and I have my little shtick about, when I was in, growing up, we always went to church, and once a year the priest had to ask the congregation for money, and everybody looked down and look at their feet, and half the church didn't show up that day, and because money was a really uncomfortable thing to ask for. And I think that we as trial lawyers, that's one thing we can also practice is our ask, because I think Nick Rowley's success, among many, many other things, is, man, when he asked for money, I mean, I think now he's asking for it right up front, in opening. We're asking for $20 million, like practicing that alone is a big part, and getting going deeper into our own relationship with money, I think is a big part of being a trial lawyer. And you'll go ahead, Kenny.
When I was gonna say, one Nick's things is like, don't ask them. Tell them.
Mhm.
Ladies and gentlemen, this is a $20 million case. At the end of this case, you're going to see that when you match the law and the evidence, that the verdict should be at least $20 million. And it's
Yeah.
okay.
And right, but Kenny, that's so funny you bring that up, because in that I always struggled with it, mostly because I grew
Oh
up
yeah.
not about money, and so asking for money was really uncomfortable. I did a focus group once, and I embedded one of my dear friends into the focus group, and we went to dinner after with a couple other friends, and he was just railing me when I asked for $10 million in the focus group because he said, I said something like, and we're going to be asking you for $10 million. And then I like skated off the stage, so to speak. And it was, and I remember, we were laughing, but the serious point was that did feel uncomfortable to me. And so there's two things that I think I wanted to go down this road about the money, the ask is that we all should work on our relationship with money. Trial Lawyers College is a great place for that. I just went to one of their programs in Atlanta, and it was all about doing psychodrama on our relationship with money and coming up with ways to ask for it. And inner circle guy Lloyd Bell was there, and Lloyd, obviously tremendous trial lawyer, huge verdicts, and watching him even struggle still asking for money was just so humbling and also inspiring because if somebody like him is struggling, we're all struggling. And so there's this real thing in the ask as a trial lawyer because I think it's a real important skill, and I love what Nick is doing, like you just shared. But to do that, I really think practicing in front of other lawyers is critical. It's, so sometimes when we do these trial by humans, I'll practice the Friday. So we do them on Saturday mornings. I'll practice on a Friday, I'll do a practice focus group. And so we've done jury selection, we've done openings, mini openings, and now we're on direct and things on witnesses. But so I'll practice and it'll go great, and the focus group will give great feedback, and I felt good and comfortable. And then Saturday morning, I'll wake up to go do it in front of these other 8 or 9 or 10 lawyers participating in the program, great lawyers, including Henry and Joe. And man, I mean, I'm dying inside. I mean, my heart, my breath. I mean, I'm like forgetting things. I'm stumbling over my words, and so it tells me that when you made that comment that we should make our practice conditions harder than the actual performance time in front of a jury, I think that's absolutely critical. And if you really want to think about it in a way that makes sense to trial lawyers, we're always trying to make sense out of things, right? That's our logical mind. That's why we do what we do. But the one thing is, if you think about if you ever participate in any kind of competition outside of being a lawyer, whether it be a sport, whether it be a speaking competition or whatever, you practice. I mean, I was a wrestler growing up. We practiced sometimes 2 times a day, sometimes 3 times a day, and you were working out other ways, lifting weights, running, whatever. You were practicing your skill over and over and over again. So when you went out on that mat or whatever your field of play was, you went on and you could execute. And actors do the same thing. Politicians, people aren't just getting up. Very rare. I mean, I'm sure they're out there, but it's very rare that you can perform at that level without a lot of practice in any field. And so, why are trial lawyers not emphasizing practice more of their skills? Because they're doing the same performance when they go in front of a jury.
No, I remember years ago, Rick Friedman was talking about the importance of spending time with witnesses. And his point was like, hey, um, this is where pretty much all your evidence is either going to come from or who it's going to come through. So if you're preparing for trial, what is it that's more important that continues to get in the way of spending time with witnesses? And to your point, if in the practice of law, it kind of goes back to, all right, what is the highest priority that we're assigning to our development as attorneys? Is it making sure we're getting better on the medicine? Is it making sure we're getting better on AI? Is it making sure that we're getting better at delegating so that we can take on higher level responsibilities? And I think the answer is yes, to any or all of it. The more important question, however, is for me, to what end, right? Like, am I doing those things so I can just make more money? Am I doing those things so that I can become a better trial lawyer? Am I doing those things so that I can spend less time working and more time with my family right now? And again,
Mhm.
I don't assign judgment to any of it, but I just think going into it, thinking more, and Chelsea and I have talked about this a lot. We were talking about it yesterday. That outcome oriented, objective oriented, goal oriented thinking will then dictate where I set my priorities schedule wise, how I'm allocating my time, and the skills I'm working to develop. And Tim, one of the questions I had for you is when we're talking about um, becoming better trial lawyers. I mean, from openings, direct, rebuttal, I think is an overlooked skill. You know, cross motions, close, final close, rebuttal, all of it. Uh, are there certain exercises, certain techniques that you're working on that you have found most beneficial?
Yes, definitely. So first, and it's going to sound a little woo-woo, but
Oh man, I love woo woo.
okay. Well, I'm gonna get a little woo with you. The first thing is that one of the skills that helped me be good at all those things was meditation. Michael Leeserman introduced me to meditation years ago, and he, at first I thought it was just, really not for me. Maybe it was a little uncomfortable. Uh, how is this helping me? With kind of probably some of the dialogue in my head. And then I started to get more serious about it as I started to get more stressed out about, working in this field. And so meditation was one thing that really developed my skills. Another thing to put in the toolbox of a trial lawyer to help those skills along that's a little woo-woo is coaching. I coach with Sari Delamotte, and I can't tell you how big of an impact or large of an impact, not only personally, but also as a trial lawyer. But really, they're tied together. If you talk to Joe Fried, I mean, I just love Joe Fried, right? And Joe just has this big thinking mind. And even in the last episode you had him on, he talked about this universe where we're really all kind of connected. You got to find that connecting point. That's the way he thinks. And, one of the things about coaching, the way I think about it from Joe's perspective, would be that coaching helps you get in that right space to be able to go and prepare for a good direct, a good opening, a good jury selection. And the coaching helps you get rid of those mindsets that limit us. And so coaching would be another aspect I think is important to being a trial lawyer. And I'm going to get into more of the technical side of it, Kenny. But the third aspect of the woo-woo side of all those things, is really the to I personally believe this because it's worked for me and it wasn't working for me. When I lost that case at that time, I probably had in my firm a couple hundred cases, a lot of small ones, some large ones, like the one I tried and lost. Then I had, obviously, like all of us, outside activities going on, family and things like that, and and um, and I had a big team, and I was, by the way, now taking me back to that fourth grade kid that looked at this book, was like, how can I make money? It was to be a lawyer, like Belli, and now that had come full circle because I'm sitting in my office. I have been making money. I had this horrible loss, and I'm looking myself in the mirror, like, where are we going here? And so the third aspect, or the thing to put in your toolbox from a woo-woo standpoint, is to get really clear on not only what area of law do you want to be really good at and try cases for, but also in that area, what kind of cases and clients do you want to take? Because I think that makes a difference in our performance at trial, is whether we have a heart for it or not. And because to be a trial lawyer, I really feel like you got to have a heart for not just the work, but the case and client themselves. We've all been on the other side of a really nasty client, it's really hard to understand them, and it's like, let's just settle their case and get them out of the office, right? I mean, come on, we've all been there. And so I would say the third component is really get really clear on what kind of cases you want to work on, what kind of clients you want to work for, and screen them early on. Is this a case I could feel my heart is in to go to trial on? And I think when you do that, then you can start getting into the technical side of answering your question. How I've been honing my skills is, using consultants. Sorry, Delamata is a great one. Jesse Wilson is another great one. Philip Miller helps me with the preparation of depositions and opening statements. He's a great one. And there's so many, right? But getting consultants in your case and having them get on your feet, I can't tell you how many times Sorry and Jesse would say, I'd say, hey, here's what I think the case is about. And they're like, okay, get on your feet and tell me. And I'm like, no, no, I'm sitting there sipping my coffee, like, no, that's uncomfortable. But that's exactly how you hone your skills, is being uncomfortable. And so, working with consultants, I think that get you on your feet in practice are really critical. And it's critical in how that performance is going to play on your, so let's just take your opening statement. By practicing it with a good consultant, can really help you see where your weaknesses are, not just in your positioning, but the story you're telling, the sequence of the story you're telling, the roadmap of the opening. And there's just so much in there that practice can help you really, by the time you go live, put on just a bang up opening statement.
And Tim, I think you make a really important point too, because I think probably like everyone who's listening to this has been guilty of it at one time or another. Of, you'll have an opening statement or a direct exam or a cross exam or whatever it may be in your head. But yeah, when asked to actually get up and deliver it, it's like, well, but I haven't practiced this. And it's like, then let's practice that.
Yes, absolutely. Kenny, I do this with my depositions. Joe Freed taught me this, is to actually role play deposition prep on the big ones. And there's a practicality to all this. I don't want people to walk away and be like, "Oh, Tim says you gotta do this on every part of your case." No, I'm not saying that, because I don't think that's realistic with all the other drains we have on our time, court and depositions and all this. But, role playing both for depositions, key witness depositions, and key trial witnesses, I think is critical. Getting into the place of that witness. I had a case against UPS, and we were there was a tipping point of where we were going to get punitive damages. And I had this whole outline. I can take a truck driver's dep pretty much in my sleep at this point. And the old way or traditional way is, to show them the rules, show them how they violated the rules, and just crush that truck driver. And that has just changed completely for me. Kenny, and Trial Lawyers College had a lot to do with that. Joe Freed had a lot to do with that. If you ever watch him, Satcha Oliver, I mean, my goodness, that guy, depositions are trial. That's a must book, by the way, in your toolbox. But Kenny, the part about the prep, when we role played it, I got in this guy's psyche. And what I learned from getting in his psyche was this guy came from a really tough neighborhood, and UPS was his way out. My way out of becoming like Belli was, UPS was his way out of the neighborhood, right? And once I got into that role, now we started practicing from that place, that deposition, to the point where we walked him down the road, and in a very conversational way, about how UPS put him in this truck when he shouldn't have been in the truck, because he was overly stressed because of the discrimination they were putting on him, that resulted in him making a really bad decision that day, and that was why the wreck happened. And boom, punitive damages were granted in the case. And if I had taken a traditional deposition and not practiced that deposition, how I had it in my head, how I would take a traditional truck driver's deposition, none of that would happen. And so, what we do need to practice these examinations as well. And I think, like with Satch's book, Depositions Are Trial, the more we practice our depositions and prepare those as if they're trial testimony, which I think is brilliant and I love it. And I'm sure you guys are doing it over there, Kenny, because you wouldn't be doing as great work, I think, if you're not. But I think that having that practice at the deposition phase is practice for the trial phase if you're going to take Satch Oliver's work. And I do because I think that is a big part of practicing your examinations. Stephen Covey, that famous author, he always that great saying that I love is start with the end in mind. And I think if you're going to be a trial lawyer, you have to start your case with the end in mind. How do you want it to look? I know Phil Corboy here in Chicago. He's been one of the greatest trial lawyers in Chicago, and I think he's pretty well recognized nationally. He always used to write his closing after he met with his client, and then he would fill in the blanks as the case went on. So, but anyway, I think it's important.
Yeah, and Tim, going all the way back to role playing, I'm glad you talked about it, but just to highlight this point, when you're role playing, you're not just, again, thinking through the questions that you may ask as Tim Whiting of this witness or this lawyer in your office who you pulled in to kind of play some patsy witness. I mean, you are role playing also, and a lot of time from the perspective of the deponent and
Yeah.
understanding their motivations, understanding the why this all happened, again, from the perspective of be it the defendant or other witness, which I think is so critical.
I think it's absolutely critical. And you can just, by the way, I used it in a deposition example, but that should be the trial example as well. And again, that comes from practice, getting either your witnesses in to practice in front of a focus group, work on your questions, work on your outline, your roadmap for them, what you want to get out of them, the important points, especially if you're talking about, for instance, pre-existing injuries. You really want to get into early on what their past looked like and how they stayed completely functional. Because the defense wants to make it out like, oh, this crash was just a big coincidence, right? But telling that story of that witness from the perspective of how functioning they were before, despite some of these pre-existing things, really tells the story of how the crash did turn their life upside down. So, that comes from practice, right? And again, it's a skill that practicing even cross-examination skills. I had a trial in April, downstate Illinois. It was a really tough case. And when I went to trial lawyers college, one of the things I loved about learning about cross-examination that kind of took the stress out of it was that that we all look at cross-examination as this thunderous, crushing, Perry Mason kind of moment, right? And if you don't do that, you lost your cross, right? And it was so freeing going, and I think Rex taught and Joe Freed taught and Nick, even in some of Nick's courses, is to look at cross-examination as telling your client's story through the defense, right? And that's a big turning point, I think, in cross-examination at trial and being a really good trial lawyer. And so this last trial I had, I remember putting that to work, and it was a voc rehab defense expert about how our guy could go back to work. And that what he was saying was that he can't go back to work as a truck driver, but he could go back to work, bagging groceries or what, and not to take anything away from any of that, but things that he didn't want to do was basically the point. And so I was thinking of this thunderous cross I have to do, and I was like, no, take it easy, Tim. Remember what you learned at trial lawyers college. Remember what you learned from Joe Freed and all these other great lawyers. And so I remember sitting back, and then I got my co-counsel in the room, and I said, let me practice this cross on you. And she just loved it. And so we went in and executed a trial, and it went beautifully. And it just was something simple, which was that this guy loved his work, right? This expert loved his work. I asked him why. I spent 5 minutes just going into why do you do what you do? And tell me about that. And he was really getting into it, and the jury was really animated and everything. And I said, so it's really important to you to be able to choose the kind of work you do. Now, I set that up in jury selection as well, because every juror said that was important. So he gave me that. And then I said, Dave can't, right? And the guy said yes. So end of story. That's the cross examination. I got to stay myself because I'm not that thunderous person. I'm probably too nice if somebody were to critique me for cross examination. But I think you got to be who you are and then figure out a way to still get what you need out of a witness. But Kenny, the real point in all that, though, I want people to hear is that didn't just happen. That was years of working to become a trial lawyer, to be able to do that one 10 or 15-minute examination in my recent trial. And that's why I think it's so important. The other part of the toolbox, if you will, to becoming a trial lawyer is listen to people like Joe Freed and Nick Rowley and Eric Penn. Eric Penn, who's just a phenomenal trial lawyer. Eric, when he has this concept of the most important juror. Jesse Wilson really gets into that. And, the most important juror is you as the trial lawyer. And that's when I talk about having a heart for a case. Like, if you don't, then maybe you shouldn't be in the case. And I think it's important to really have that conversation with yourself, because to be a successful trial lawyer and to go and do right by that client, if your heart is not in it, then it's not fair to them. And I really feel strongly about that, because the times I've won and done a really good job, I honestly can say the defining factor was that my heart was in it. The times that I have lost was either when I wasn't practiced and I wasn't skilled and I wasn't performing up to level, or that my heart wasn't in it and I should have stepped out. And so I think these conversations are important to becoming a trial lawyer, and listening to other people talk about these things like we're doing now. Um, but like, okay, so for instance, in this trial by human mentoring thing, Nick Rowley got on and he talked for a whole hour, but there was one thing he said that I think that will change the way I put on a trial from now on, which is why it's so important to listen to your podcast. I encourage all listeners, don't just tune in after this one, tune in to every single one Kenny puts on, because they are amazing. Kenny, I have gotten so much out of all of your podcasts that you've had, all the guests. I always have taken something from them to be able to add into my skill level and practice it, and we'll be using it in trial in the future. But Nick said the most important witness in your trial is the first one you call after opening. I never thought of that until he said that. And then when I started thinking about it, I thought to myself, holy crap, that is so true in all of our trials. And so now I look at my sequencing completely different than I did before that statement.
And was he talking about discrediting the defense opening statement through that first witness?
Yes, exactly. Yes, it was brilliant.
It's brilliant. I mean, so, you know, when it comes to opening, I mean, I've heard not just Nick, but others talk about, hey, the time to pat yourself on the back is not when you get done with your opening. And it may not be when the other side gets done with their opening, but perhaps after the witnesses you've called have totally discredited the other side and shown why you're right and they're wrong. At that point, maybe you can go one pat. But again, the time is not this brilliant oration, all these incredible different things that you've done to lay out the case. It's seeing if your case can withstand the scrutiny of the defense, and if your case is also strong enough to expose the weaknesses, hypocrisies, and vulnerabilities of what the insurance defense lawyers put up.
Yeah, 100%. I think that, and I take this from my wrestling days, that you're wrestling for the full 6 minutes. You don't let up once until that buzzer goes off. And I look at trials the same way. And, until you finish your rebuttal in closing, your job is not done. And so, there's definitely days where you're winning, right? And you come home and you're like, okay, let's get ready for tomorrow. But hey, let's take a moment. We crush that guy, we crush that lady, whatever in the trial. But and I think that's important. And I think it's equally important in a trial when there's a momentum, swing downward, not to get caught up in the downward slide either, and start pulling up your stakes. It's that's why, I tell you, Kenny, I think of when I think of trial, I think of like NFL quarterbacks. I mean, these quarterbacks have to have the shortest memory and must have so much mental coaching, from play to play, or from possession to possession, quarter to quarter, half to half, whatever. They are under such constant pressure to forget about whatever mistake they made, whatever change in momentum took place during the game that might not even be in their control, by the way, and come out firing, right? And I think that's a really good analogy for trial lawyers. Is that we can't get caught up in the ups and downs and the swings. We got to be that steady warrior, with a short memory, and just keep putting our case on right to the bitter end.
Tim, what's next? What are you looking at for the next year, 2 years, 5 years? I mean, where are the areas where you're most wanting to continue developing as a trial lawyer?
Yeah. So, I've been a bit of a late bloomer, Kenny, because when I realized through that terrible loss, it was, I think, around 2007 or 8, I've really started honing my skills just in, the last, 10, 15 years. And so I feel like I'm just coming into my own, even though I'm not exactly a young man. But I feel like a young man, and I feel like that in my trial practice, that my next level of success in my career is to get into trial on some of these really big truck cases. And so to do that, I have been upping my own game, both in practicing, reading, going to certain very key conferences or programs like Satch Oliver's. Anything with Trial Lawyers University is great. Anything with Trial by Human. And I would say anything with Joe Freed, if you can find anything with him, or Trial Lawyers College, even add that to the list. And so I'm going to these programs, and no longer am I going just to kind of, say I did it. Um, but now I go with true intention, because I have the skills. I have had some trial victories that have been good, and great. And now where I want to move in my career is to go into these things with the intention to come out a better trial lawyer, but also one that is empowered to just say, go to trial. Here's a great example, Kenny. It just happened yesterday. So we have a case down in Arizona. It's on a very difficult double motor carrier issue. And we don't need to get into double motor carrier, or it's really called the statutory employment doctrine. But it's an area that a lot of lawyers are missing as a defendant in a case, because you have these two motor carriers, and holding the one responsible as a motor carrier is a real skill. And be happy to talk about that sometime. But Eric Penn was the one that taught me that. Joe Freed, of course. And we have one in Arizona. And so we built this case up, and they asked us to go to mediation next month. And so we were preparing the mediation statement, and we did Satch's program of getting the admissions and the depositions, and we prepared some great lay witness testimony, medical testimony, and tied a lot of the defense witness exams into damages, into liability, that kind of thing. Really, like, I guess what I'm trying to share is that all my skills as a trial lawyer that I've been working so hard on kind of came together, at least in this case so far. And so we're doing the mediation statement, and our initial thought on the ask was one thing, and then we started practicing it, and then we did it in front of we performed a kind of a clopening and before a focus group last Friday, and they were coming back at higher numbers. And then the more we worked on this presentation, the more I was empowered to say what I've been wanting to say and will say now moving forward. This case, first of all, I check my heart. I have a heart for this case. I have a heart for this client. Number two, I have a heart for the issue. That's at center stage in this case because I have a lot of knowledge on it and I've gained skills on it. And number three, I've taken all my trial lawyer scholarship skills during the depositions and have gotten my key admissions and I have the case really primed for trial. And so going into mediation, our number is X. And if you don't want to pay it, it's going to be fine because we'll just go to trial. That to me is the next step of being a trial lawyer, is not going in with the intention of wanting to settle. Let me clarify that, not wanting to
No,
settle.
you said it right. You
Yeah,
not. I think the way, I mean, how I think of it is, am I working up this case? Am I getting it ready? Am I doing all this work with the primary objective being, to try the case if they don't pay the number? Or am I doing all this work and then once all of a sudden they start, and because I have to I've got to gut check myself. I may say, here's the number, all of a sudden they're at, 5/6 or 90% of that number. And it's like, wow, you get a lot of attaboys. Um, or am I preparing it because I believe in full justice in that case for that cause with these facts? And that's what we're doing. And if they get to the number, wonderful, the case will resolve. And if they don't, then we can't settle. In other words, it's like, is it option A, until met, or is it like maybe I'm on A, maybe I'm on B, let's see what they offer?
absolutely. Yeah, it's an empowerment thing. And I think it only comes from when you've honed your trial skills. And you're absolutely right, Kenny. And the big takeaway I want people to hear from this example that you and I are talking about here is that because I have developed the trial skills that I think are necessary to go to trial and win, and have, were on full display in preparing this case and seeing it as we're putting it together in the mediation, is that, hey, you don't want to settle, we're ready to go to trial. We're ready because there's a small voice in many trial lawyers, because I'm not sure it's all of them, but if I'm talking to you, this is how you check that voice, is by preparing your skills. But the voice is that inside, it's like, I could lose. Oh, I got a lot of money in the case. Oh, it'd be nice to have a good settlement. There's just so many justifications and I personally believe, if people are being honest, we all have that voice. And and that when you put on in the Bible they talk about the breastplate, of justice, I think it is, and uh I think about that like if I transported myself back to 2007 and 8 when I was in that case, yeah, I wasn't afraid to go to trial. That wasn't the issue. The issue was I wasn't skilled enough. And so after that, I had to really get skilled, because otherwise that voice was going to win out every time and I was going to settle all my cases. And that's not who I wanted to be. It doesn't fulfill me. Um, Now, that doesn't mean certain cases shouldn't settle. Absolutely, some cases should settle and will settle. But the more you empower yourself as a trial lawyer and with your skills, and in that turning point, you can shut that voice off and say, here's our number. If you don't if you don't want to pay it, it's okay. Like, it doesn't have to be a big, back and forth with the defense. It's like, I respect your position. I hope you'll respect mine, but I'm empowering myself to go to trial on this case because I'm ready to go. And I think that's the difference. When you're not ready to go, then that voice wins out at the settlement stage, for right or for wrong. And so, to become a real trial lawyer, you have to be able to quiet that voice. And you quiet that voice, I think, through being prepared, practiced, skilled, going to these conferences that teach trial skills, getting on your feet, getting on your feet in front of other trial lawyers, because again, I think it's a great way to really get some great critique and grow. And the more uncomfortable you are, like when I said Jesse and Sari would say, get on your feet and show me. I realized the more uncomfortable more times I put myself in that uncomfortable position, the better I get at performing.
Yeah. Tim, this has been fantastic. I mean, you and I could talk we could do this for the next 8 hours. My
Yeah.
family wouldn't be too pleased, and tonight's actually the start of Yom Kippur, so no,
Oh, right.
no one would be happy with me. It's been incredible, um, always enjoy our conversations. I've probably enjoyed this one most of all because it's been our longest, and I'm just very grateful for you, for the work you're doing in the field, for coming on today. For folks who want to get in touch with you, be it about a truck case, about developing skills as a trial lawyer, about anything that we've discussed, what's the best way for them to get in touch with you?
Sure. You can email me at tim@whitinglawgroup.com. That's WHITING. So tim@whitinglawgroup.com. Or feel free to call me on my cell phone. Joe Freed picks up his cell phone for me anytime. And when I said to him, Joe, what can I do to repay you back for all this? He said, pay it forward. So I'll give you my cell phone, which is 312-399-1655. And I will be sure, if I don't pick up, to get back to y'all. I just, Kenny, as you can tell, I just love this stuff. And like I said, I feel like I'm just finally coming into my own and really excited to be a part of this golden era of being a trial lawyer, because I really do feel like we're in a golden era of being a trial lawyer.
I couldn't agree more. There's so many great materials, so many great resources, and again, thank you for being one of them. Ladies and gentlemen, this has been Best Practices with Kenny Berger, our guest today, truck lawyer specialist Tim Whiting from Chicago and handling cases all over the country. And we look forward to being with you again soon. Take care.